dollar stores. Mr. Wiggins?
Yes, sir. I'm Bob Wiggins, representing the plaintiff putative class. This case involves single job store managers and a single issue, which is whether women store managers should be paid the same as men for that job. The district court said that that claim is no longer, quote, legally tenable. He said it was legally untenable, per se, after Walmart. That he did not need to hear evidence. He could rule on Rule 12 because no amount of evidence for a gender discrimination claim would ever suffice after Walmart. He also, I think, greatly exaggerated what Walmart is about. Walmart was simply a disconnect between the claim and the evidence in that one case. They presented regional statistics for local discretion. The court said you can't do that. They presented a Dr. Bilby who testified about a culture of discrimination, but Dr. Bilby admitted he couldn't say it applied to more than 1% of the stores. The court said you can't do that. And on the anecdotal evidence, the court said, I think 8% or 12% right in there of the anecdotes were not enough. The key point of Walmart, though, is that evidence is needed. The district court said no evidence is not needed. We'll rule on this on Rule 12. He did not have a single deposition, did not have a single expert report.
It's not quite that simple, because the federal rules encourage district courts to decide class certification at the earliest practicable time. And talking about the discovery here, but the district court did make a finding that the, quote, plaintiffs have had adequate time to conduct discovery, and they have indeed conducted significant discovery in this and other similar cases against defendant in other jurisdictions. I mean, you've sued them in numerous places. It's not as if this class action just emerged sort of sua sponte. It was litigated extensively in Alabama before it was even removed to the Western District of North Carolina.
Well, even if that were true, Judge, that evidence wasn't in front of the court.
Isn't Walmart a real problem for you, because the Supreme Court there makes the point that nationwide class actions are really unwieldy instruments, and that it's a big weight and albatross to dump on a district court's shoulders. I mean, Walmart's a really tough case from you. I mean, it seems to me the difficulty you face is that we're getting, at the Court of Appeals level, we get squeezed from two different directions. One, we have the standard of review below, which is abuse of discretion, and all the cases emphasize the breadth of the district court's discretion in terms of class actions, because the district court's going to have to be the one that's going to manage this case, and it's no simple undertaking. And then not only do we have the standard of review staring at us from below, but we have the Walmart case glaring down at us from above. And between the standard of review and the Walmart precedent, some cases squeeze a court of appeals pretty hard. Other cases, not so much. But a case like this, you got a Supreme Court precedent and a tough standard of review. That's where the freedom of action of the intermediate level in the system is fairly limited.
You don't have that squeeze on a Rule 12, in my opinion. The standard is not abuse of discretion. If he had entered findings
Whether the certified class is not an abuse of discretion?
on a Rule 12, no. You don't have discretion to rule on the adequacy of a pleading. It either passes the test or it doesn't. There's no discretion to say, well, I don't think I'll take this case. That comes at the evidence stage. The abuse of discretion comes, and then the clearly erroneous rule comes at the discretionary stage after you've heard the evidence, after you've entered the findings of fact. And that's the key ruling in Walmart. And the Supreme Court twice this year has revisited the issue. In Amgen case in February, and the Comcast case in March. The court stressed the evidence, the need for rigorous analysis of the evidence. There's nothing to suggest that you can do this on a Rule 12 motion. There's nothing to suggest that women can no longer even plead a case under any circumstances.
Don't we have a big difference, though, Mr. Wiggins, between your complaint and your amended complaint? I mean, a very big difference in terms of the substantive allegations?
No, I do not believe so. The original, this appeal travels on the original complaint. This appeal, and that original complaint says this is a centralized pay system. And that's what the Supreme Court said is certifiable.
Right, but didn't you tell the district court that your case was just like Walmart?
We said that at the time of Walmart in the district court decision. Back in 2008, we said we're just like the Walmart district court. We never said we were like the Supreme Court Walmart, which was diametrically opposite. The lower court said this is a centralized system. The Supreme Court says, no, it's a decentralized system.
But weren't you pleading, my problem with the case, and if you could address it, seems to me that your amended complaint did arguably what it needed to do under Walmart, to allege centralized decision-making, centralized controls, that your original complaint was very general and really wasn't specific in any respect as to the actual actions taken and their effects. For example, your amended complaint is very clear that there are external hires versus internal hires. The external hires are disproportionately men. The internal hires are disproportionately women. You were quite specific, and I don't see that in your amended complaint.
We did not know that at the time the original complaint was in, but we did, in opposing the Rule 12 motion, we said, if you'll let us present the evidence, this is what we'll show you. And we made the point you just made and others. And we said, even if you don't grant the amended complaint, we are telling you what we think the evidence now is showing us after 3 years. And let me say,
This is, I mean, it's almost a case for judicial estoppel, isn't it? Because you say, in your original complaint, you say that the Walmart case involved virtually identical claims of sex discrimination in pay to those brought in this case. And so you were willing to ride with Walmart when the Ninth Circuit was going your way, and then you reversed field completely. And the same thing happened with respect to the whole question of centralization versus subjectivity. Your initial approach said, I'm quoting from Joint Appendix 53, defendant's pay decision and our system includes subjectivity and gender stereotyping, and then you talk about, we know of no other criteria other than the gender bias subjectivity. And then when the Supreme Court decision comes down and says that the single flaw in the Walmart case is the problem of when Walmart identifies this very subjectivity and the very discretion as the whole reason that defeats class action treatment, because the truth or falsity of a claim can't be determined in a single stroke, then you switch ground completely. You switch ground as to subjectivity, you switch ground as to Walmart. It's like independent of the facts, you're just going to do what suits at the particular time. And it's almost a case of judicial estoppel.
Well, that's just not what the complaint says, Your Honor. The complaint says it includes subjectivity. It does not say it's decentralized subjectivity. It never even hinted at that. We have always said that there is centralized subjectivity, and that was one element. And it's a small element, because what happens is the executive vice president at the corporate department can grant exceptions to the otherwise fairly lockstep pay system. Now, we have to acknowledge in the complaint that, yes, at some point, some degree of subjectivity comes in, but it's at the corporate level. You won't find a word in the original complaint, amended complaint, our briefs, anywhere that supports what you're saying.
I don't know, normally subjectivity is always alleged as an individual matter. I've never known subjectivity in these kind of cases as being corporate subjectivity. But to get back to the main point, the Walmart is concerned about the unwieldy nature of a nationwide class action when there's a great deal of variation and diversity of practice within the different units and among the different managers. And here you have a corporate structure with 95 different regions. The vice president heads that region. And then you have a lot of districts, and each district has 10 to 30 retail stores. And in each one of these regions and districts and store levels, you have different layers of management, and they're making different kinds of decisions. And the whole point of a class action is there's supposed to be a large degree of commonality to it, and they're supposed to be practically manageable. And this, frankly, seems to me to fail on both counts, because I don't understand how in the world you'll manage something this vast with this many different managers, with this many different units. And in addition, what commonality there would be. I mean, all managers are not the same. There are going to be some that have very progressive instincts and others that don't. But they can't be just thrown into one box.
Well, Judge, if the evidence eventually says that, then that might become the case. But we don't think the evidence will, and we ought to have the chance to present the evidence. You ought to have to make findings. That's what Walmart says. You can't just assume every gender case is a Walmart case. We say that this case involves centralized criteria, such as Judge Keenan laid out and others, and that we can show that centralized criteria is what's causing the disparity. Not the localized or anything localized.
That's your amended complaint, though, isn't it?
That's our complaint from day one. If you read our original complaint, it says that we are attacking a centralized system. It says nothing but that. And the idea that we can only have subjectivity at the local level is just wrong.
Okay, but Mr. Williams, doesn't this really come down to your amended complaint and whether you should have been allowed to amend your complaint? Because you found out all these different specifics during your discovery, didn't you?
Yes, that is a big.
Isn't that really the issue here?
Well, they're both they're intertwined.
You didn't identify the specific issues in your original complaint that you identified in your amended complaint. You just argued concepts.
Correct, and that's because the system changed. Judge Wilkinson said about the earlier discovery, which was in the early 2000s. That's true. But the system changed by the time we filed this case. This is not the same system. That was a decentralized, subjective system. The company decided not to do that, probably because of the Walmart decision in California, because they're both in the retail industry. They somewhat compete with one another.
Okay, so when you
And so by the time we come up to this case, 6 years later, we have a different system, and we gradually learned about it. We weren't allowed to present the evidence of how it was different. And that's what our
That's your
case is.
argument for abuse of discretion, then you're saying it was a different case by the time you were ready to plead an amended complaint.
We're not arguing an abuse of discretion in the sense of if he had ruled on the evidence. We're arguing that he had to hear the evidence.
Not allowing your amendment.
We think that's intertwined. It grows from the same error. The error is that Walmart makes it per se untenable to bring a gender claim. That's the error on the amendment. That's the error on the Rule 12. And that's the error why we didn't get any evidence in this case and why you have no fact finding and why all those facts that Judge Wilson just went through are not in the record. Not one thing that you went through, Judge, is in anywhere but they're a brief. So that's the problem. And
The problem is that you've got a finding on the part of the district court that says you've had ample opportunity for discovery.
that's just not true.
Hold on, you mean it's a clearly erroneous finding? The district court found, quote, plaintiffs have had adequate time to conduct discovery, and they have indeed conducted significant discovery in this and other similar cases against defendants in other jurisdictions. Now,
But that's just not true. We didn't have any discovery at all, except we had not one deposition. We had not one expert report.
what do we do with the district court's finding?
It's not a finding. It's not a factual matter. It's a procedural issue. He just was a new judge on the case. He did not understand the previous judge's rulings, apparently. But it's a matter of record that we did not get discovery. They kept us tangled up procedurally for 3 years, where we never got to the point of doing discovery. The information we got was informal through mediation. And that's how we began to piece this together, through an informal process. There's no evidence in this record.
I think what the district court found here was a case that was just jumping back and forth in front of him. On the one hand, it says it's similar to Walmart, and then on the other, it says, no, it's really different. And on the one hand, it identifies this as the central flaw in Family Dollar's operation, the identical problem that was found by the Ninth Circuit to be the flaw in Walmart. And then, once the Supreme Court does in rules as it does in Walmart, you do a 180.
No. The judge, honestly, the Supreme Court did a 180 on the Ninth Circuit. The Ninth Circuit said it was...
They're entitled to do that.
I know, but I was comparing myself to the Ninth Circuit. Said it was a centralized system. The Supreme Court does a 180, and you're saying I'm stuck with that too? I didn't even know it at the time.
No, I'm saying that what you said before Walmart, the Supreme Court decision in Walmart, and what you said after were two entirely different things.
Yes, because I said it was centralized when the Ninth Circuit said it was, and then when the Supreme Court says it's decentralized, I said, well, that's not me. That's not my case. And I couldn't do anything but. But here's the point. Let's let the evidence speak. Thank you.
May it please the court, I'm John Wester of Robinson, Bradshaw, and Henson of Charlotte, counsel for Family Dollar. With me is my colleague, Gerald Matman of Safer Shaw of Chicago. It is exactly right that the Walmart decision changed fundamentally the landscape of class actions. That's well described in the colloquy just now with counsel.
But it did not bar categorically all national class actions, did it?
Precisely not. It was my next sentence.
Right.
The phrase used several times by my distinguished opponent concerning per se, those phrases do not stand properly beside a correct analysis of Walmart. To the contrary, and this was also omitted, the motion that Family Dollar made was to strike the class action allegations only It is not a regular 12 motion. It was highly particularized. I have it with me. It's easy to find it, Joint Appendix 267 and 268. I will read one sentence to the court. Pursuant to Federal Rules of Civil Procedure 12C, 12F, 23D1D, which is well known to the court as removing those who should not be in the class, and the Supreme Court's opinion in Walmart versus Dukes, Family Dollar hereby moves to strike plaintiff's class allegations. Indeed, at the end of the district court's opinion, the district court makes very clear that all of the individual claims, and there are 49 remaining, 2 had been dismissed, 49 of the 51 go forward. In fact, a subsequent order said, get a move on, these cases have got to go to trial. Complete with the rights to attorney's fees if the women prove, the ladies working in these stores prove they are the victims of discrimination. Now, that's what happens, and that's the context of what happens here.
Why shouldn't they have been allowed to amend their complaint? I mean, the amended complaint is manifestly, substantively different from the original complaint. I just totally disagree with Mr. Wiggins on that. But when you look at the amended complaint, they're quite specific on what's going on at the corporate level, at the divisional level, and it's very different from Walmart. So why shouldn't they have been allowed to do that?
There are 2 reasons, Your Honor, that come to mind now. One is, and the most convincing to me, is yes, they are different, and I agree they are significantly different, but they would not take them past the bar that Walmart and other cases create.
Why not?
Here's why. The allegations, and they're handy. I would encourage your attention to Supplemental Appendix 1293, and the paragraph is 36. This is one illustration. There are others, but this is one. It says here that the pay raises are restricted by a corporate imposed raise pool and budget, and that there's a raise percentage. And then here's the sentence. Exceptions above the corporate imposed pay raise percentage are decided by regional managers. I believe they mean district managers, but nonetheless, and divisional vice presidents.
Right, but it also says the corporate headquarters establish the factors that are evaluated and the weights to be afforded to each factor. The compensation system is structured to pay, and goes on.
Yes.
So what they're saying is that the corporate policies, just like in the Merrill Lynch case in the Seventh Circuit, the corporate policies are directed at the national level and are implemented by direction from the national corporate headquarters.
That's right. I agree with that, and I also know that, I trust you would agree, that it's done by people. None of those policies that are, and as specific as they are not dictated as a matter of this is the number. They are not self-executing, and each time...
Are you saying, I don't mean to cut you off, Mr. Wester, but
No.
Are you saying then that in order to survive Walmart, that an allegation in a situation like this, everything has to be done in the same building where the CEO has his office or her office?
It's not that extreme, Your Honor. It's
Well,
this.
it sounds like it.
Let me say how I can do it. It would be, and the Supreme Court says this in Walmart, quite unbelievable that everything would come to one number without some common direction. And what is not in this complaint, amended complaint, is the specific, unified, common direction that gets rid of the discretion. It refers to ranges.
Well, they say store manager salary ranges
Exactly.
are determined annually by corporate headquarters. They do not vary by store or district.
That's correct.
Exceptions are made only by the corporate vice president at corporate headquarters.
That's correct.
Pretty specific.
Yes, ma'am, it is. And it allows for, if you just take the vice presidents, it allows for actions by inside those ranges. So you would not have, Your Honor, any common answer to the question why I was disfavored if inside the range I got a number and I was a lady that was lower than a male with whom I thought I was doing, compared to whom I thought I was
Right,
doing
but
the same
They're
work.
arguing that there's a statistically significant disparity. They're saying men were granted exceptions by corporate headquarters at a rate statistically significantly greater than women.
That's right. Well, we learned from Walmart that that can be a signal along the way to show proof But what we also learn from Walmart, indeed on the statistical question, that alone does not answer the question. It does not give us the common mode of exercising discretion. Even this amended complaint does not give us the answer, does not show us the common mode of exercising discretion, and that's what Walmart says is essential. It is completely, you and I are in agreement that the amended complaint is different, but I emphasize it is not different in the direction of rescuing this complaint from the place it was headed, and that is dismissal. I do mention,
I mean, the basic Walmart model is in effect in companies across the country, and it was in effect in the Walmart case itself. And what you have in Walmart and what you have here are these basic, is this basic template. Because it's one company, because its name is Walmart or Family Dollar or McDonald's or whatever you have, because it's one company and there's one corporate headquarters, as there was in Walmart, of course there's going to be some centralized direction. If there weren't some centralized direction, there wouldn't be one company. But there's not a company in this country that doesn't allow significant discretion at the middle management level. That the vice presidents and the regional managers and the store managers exercise discretion all along the way. They grant merit pay increases. They grant waivers. Some of them decide, bonuses. And it's an interplay and it's a back and forth, to be sure. But the Walmart model is what you have here. The vice presidents and the regional managers aren't just robots. They're people that have jobs that have some responsibility, and some of them exercise that responsibility in a progressive and beneficial manner, and others are making other kinds of decisions. But Walmart says that, if you have subjectivity and some discretion at this middle management level, then you just can't try to resolve this with one sweeping ruling or one stroke, because you're taking decisions that may be highly beneficial to the plaintiffs in one region and lumping them in with decisions that may be detrimental to the plaintiffs in another region. It doesn't mean you can't get at the problem. It's just that you can't use this kind of blunderbuss. And the corporate organization in Walmart and the corporate organization here are not only similar, they're typical. And to load on the district court all this disparateness, and we haven't even gotten to the remedial problems, but all this disparateness with respect to different kinds of decisions being made, and questions about liability and who hires out of house and who hires in-house. Well, there are going to be some managers that hire in-house. There are going to be some managers that hire out of house. There are going to be some managers that have equal pay. Some managers may not. I don't know. It's a disparate problem. There are going to be some managers that hire out of house, but that may not be a discriminatory reason. It may be because sometimes you have to offer people a little more when you get them outside of the company, because they have to switch jobs and they have to move. And sometimes they have to change cities, and sometimes they have to change companies. But it's not one Leviathan moving in lockstep. No corporation does.
That's precisely our view, Your Honor. And I note that for all of the efforts made in cases like this that have the national model of a company going on, not one of them that can be a class action can be one unless there is automatic execution, self-execution of the policy. You can have that, excuse me.
I'm sorry, I interrupted you, I apologize.
No, to the contrary, Your Honor, I look at it this way, only you could be interrupted, not I.
Not true, it works both ways.
Well, but I defer to your question, of
Well,
course.
you know, it's really intriguing me because what keeps coming back into my mind again and again is, are you saying really that these cases are dead because of Walmart? You say no, but tell me, what is a common mode of discretion? I wrote that down because that's what you said.
I did say
You said
it.
that if there was evidence of a common mode of discretion,
Exercising discretion. Yes, ma'am, I did say
that
that.
that would be sufficient. Give us an example.
Well, it's not original with me. It's from the Supreme Court's opinion in the Walmart case.
Well-
But I can think of those.
Okay.
I think it would be in, if I may say, I think it would be in the significantly smaller company. You could have such a thing, but I mean significantly smaller because I can't think of many policies that are self-executing. I think the continued vitality of the disparate impact model is going to be, following Walmart, the case in which there is the test or the other ingredient like a test, like we had in Griggs versus Duke Power, that kind of case. Also, and the Supreme Court tells us yet again in the Walmart case, there are two ways to fill the significant gap, and that's what they called it in General Telephone versus Falcone.
Right, but they were talking about discretion and common exercise of discretion.
Yes,
But
exactly.
what we have here in this amended complaint, not in the original complaint, but in the amended complaint, their discretion is not here. I mean,
Well, we may see that, and I respect, we just may see that differently.
Yeah.
I don't think, it may be camouflaged, Your Honor, but I don't think you can miss it. And here is the
well,
concession.
maybe the evidence won't bear it out, is what I'm saying ultimately.
Well-
But why shouldn't they get a chance to show that store managers' salary ranges do not vary by store or district? Exceptions can only be made by the corporate vice president or at corporate headquarters. Why shouldn't they be allowed to show that men are brought in from outside positions at higher salaries than the women who are disproportionately promoted from within? Why, that's not what Walmart was talking about in exercise of discretion. These are corporate hires at the corporate level, aren't they?
No, Your Honor, and here's
Why
why.
not?
Here's why
These
not.
managers are hired at the
They are certainly hired at the corporate level.
Okay.
But here's what happens. This is, I think, a fine illustration of the rule that we've learned, that exceptions can swallow everything else. The regional managers, and there's as many as Judge Wilkinson was referring to, that comes from an opinion by Judge Niemeyer in the Grace decision. We know there are scores of regional managers in this company, in addition to the district managers where these decisions are being made, and you cannot plead yourself away from the common sense of that. And they've not done it here. The common sense of it is this. The common sense of it is, it was well summarized just now by Judge Wilkinson. No matter how you do it, there are not self-executing policies
Okay, but
by
I
these
don't know,
individuals.
Mr. Wester, I don't know how many regional managers there are.
We do know from the opinion, it just happens to be that,
Another panel of this court. I mean,
Sure.
how do I know at the time that at the time this was pleaded, that was the case? You're saying I can take judicial notice of another opinion?
I can, when it
issued by
concerns the
court?
same employer, and it's this very same company, that there is no indication, and indeed, this litigant here, these litigants here said in their argument to the district court, Family Dollar is one company, it is not a chameleon. And they said that in 2011.
They're running away from their representations, there's no question about it.
okay.
But why don't they have a right to?
Well, there are two reasons that matter to me a great deal. One is, it ought to count for something, their words and their consistent representations about our client, the opponent, and how they describe the company ought to count. This court's opinion describing the company, which they have not challenged, ought to count. My other reason, it is legalistic to be sure, but I have not said it, and I want to, is the amended complaint is not something they appealed. It does not reach this court. This court granted the 23F petition,
But that
and it's
has
not
to be-
here.
That has to be part of the decision,
Well-
because it could never be subject to review, the denial of an amended complaint.
Well-
If the court's decision denying it was not considered now, it would never be considered. Isn't that correct?
Well, I don't know how it would be considered.
Exactly.
And so I would say, but it was considered below. And it was considered below
It's
for the
appeal-proof.
reasons.
You're saying it's appeal-proof.
I am in this context saying this. It's a reviewable for an abuse of discretion. And it was within the district court's discretion below, and I submit properly exercised because he found fundamentally that it was going nowhere for the reasons Judge Wilkinson has just outlined.
Isn't the, I'm not sure I agree with you on that point, but what troubled me most, among other things about the case, are the fact that I think it's not whether what suits are dead after Walmart or whatever, but I think these litigants have played fast and loose with the court. And that what happened was that their previous representations to the court were that this case was just like Walmart. And that was in their legal filings. And their previous representation to the court was that the flaw in this corporate model was the same as the flaw in the Walmart corporate model, which was that it allowed too much discretion, too much subjectivity. And as he says, we were talking about corporate subjectivity. No, the whole issue was subjectivity at the middle management level. And the question it's not a global question, but it's a question of whether you can have an amended complaint that's significantly different from an original complaint, and filings even to the point of making diametrically opposed and diametrically different representations. And the question is, if a district judge says your amended complaint is backtracking on all the representations you have made previously to the courts and to this court, is it an abuse of discretion for the district court to take that into account as one factor? Now, we can get into the whole question about whether the amended complaint is adequate, and I think for a lot of, you've made some good reasons as to why even the amended complaint still doesn't address the significant discretion with respect to personnel decisions that's allotted to middle-level management. But what I'm suggesting to you is that there's a threshold question here, and that is whether the whole case has done a 180.
Well, that has to count. I said to myself when I was reading it, it's not just one time, but 3 times in this record, the plaintiffs have taken refuge in the Walmart case in the district court and in the Ninth Circuit 3 times. It may be that every form of refuge doesn't have its price, but 3 times ought to count, and that's what they did.
I agree that that would be troubling. If we consider that in isolation, nobody should be able to play fast and loose with the court. But aren't they saying something different here? They're saying that because of the class certification discovery that took place in this case, that the level of specificity of actions at the corporate level were learned by the plaintiffs during the course of the class certification litigation, and that gave them a basis for amending their complaint. Now, you might not believe them, but aren't they saying that? And wasn't there class certification discovery that did reveal some of this?
There's extensive class certification discovery in this case, a final point that I wanted to make, because I think that did not come through in the supplemental appendix 1258 and 59 and 1264 and 65. You can see the vastness of all that. But here's where it's important for me to be clear about it. It did not take them to surviving the Walmart statements, the Walmart opinion. And here's why it doesn't. It doesn't take them there. It doesn't get them around it. Even if the court were to allow this, which I heartily agree is it just ought not to be doable in these circumstances. It shouldn't be doable. This is a different thing from an amendment. It's in the nature of a mini revolution about their theory. But the important thing to me is what they claim they've learned, they have known for years. They've known it for years because the company under review here wasn't changing. It's not a chameleon, and they've known all these things about how the company sets its pay for years. The lawsuits, 15 of them against this company, weren't for whether there were timely deliveries of Family Dollar goods. They were about the pay of the company and how the pay decisions are made. That's what they knew, and they knew in the course of learning all of that, they learned deeper and deeper about how the company makes its decisions for pay. And those are made in a disparate manner, just as Judge Wilkinson has pointed out, and just as our brief emphasizes. And that disparate decision-making is what makes this case of a piece with Walmart. I'm in the penalty period. I'm pleased to answer further questions.
I didn't get a chance to ask my question, though. Be patient with my colleagues. Let me just ask you this. Are you saying that the national company did not make the policy of the range for laterals to be higher than those reported within? Is that your, are you asserting that? That was not a national policy to make the ranges for higher pay for laterals?
Well, I am not saying that the national company makes declarations on a long list of things, including pay and including establishing the ranges, Your Honor.
Exactly.
Exactly.
So if it was national
Ranges.
policy that established the range, and that range is higher for people who are laterally brought in than it is for people who are promoted from within, correct?
I think that's how it operates some of the time. It is not a matter of national policy, as I understand
The
it.
range is the range. We're not talking about the decision, what you give within the range. The range is decided nationally, from corporate policy, correct?
Yes, sir, but the entry, yes, sir, the range is decided, but the entry into the ranges is not decided nationally. Whether you fall within the ranges, depending on when you come in, that's a matter of a lot of factors that we're not. It would take a while to explain. But whether you fit into a range and whether you can fit into it because you're an outside hire or a lateral hire, it would be highly significant. And I note, and this really is important, I note that there is no allegation that the structure, those ranges, that the structure of that or lateral entry is the subject of any discrimination. Not one allegation, even in the amended complaint, attacks those, I'll call it, the range system or entry into where you would fall. None of that is a subject of a claim in this case.
Wouldn't all companies, just by virtue of being a company with a single corporate name and a single corporate trademark, have some general range? I mean, the way in which top management and middle management interface is that top management provides a range, but the whole execution of the range and waivers and exceptions and implementations are taken at a much more localized level.
I don't know how else it can be done. I don't know how a national company can operate without a significant number of national policies, including ranges for pay. That is the beginning of the story of each one of these cases. And we can have discrimination all along the way, but it does not emanate from the fact of, which I think is an immutable, unavoidable element in a national company, of having a variety of national policies. And the discrimination that can arises because of individuals throughout the system deciding that they're going to live that way.
Well, the national policy actually, as alleged, could cause discrimination even locally, because you could say, I have promoted managers who are equally, if not better than those laterals, but by national policy, I cannot pay you at the highest level as the lateral comes in. Wouldn't that be correct?
Well,
For example, the range for internal, let's say, is 50,000 to 75,000. The range for laterals is 60,000 to 100,000. Well, then, if that's set by national policy, then when you locally see a promoted manager who's really better than one laterally, he or she couldn't pay that person the same amount of top salary. Isn't that correct?
You could, yes, sir, you could have, you called it discrimination, you could have decisions that can't be explained in terms of logic, but there is no suggestion from that, just as Walmart tells us, that the valid exercise of discretion in those decisions breeds any discrimination. Some may and some may not.
When you set ranges, you set the very framework for discrimination. And when you make ranges different, when you know a category is statistically loaded with females, another one is statistically loaded with males. That's like saying, I'm gonna pay all people who have some athletic background, whatever, more money than people who don't. And we find that statistically men tend to fit in that category. You say, well, I didn't discriminate based on how you got in there, but that's what they're saying, disparate impact, because women have not been having the opportunities to be able to have longer ranges, to be in position to be laterally brought in. That's their claim. That's at the national level. That's what they're claiming.
Well, that's what they did claim in Walmart. You're quite right.
Yeah, but they're talking about it, then it turned out it was just total subjectivity, not a range that cabin. Here, they're saying, no matter what they do locally, you have cabined the amount. For example, you cap the salary, cap increases, don't you, for internal promoters?
Well, there are ranges, and there's a ceiling to the ranges, yes, sir, and a floor to the ranges.
But not the same for laterals, though.
But and not the same for laterals, that's right.
And that's discriminatory by their allegation.
Well,
Right?
no, sir, it's a
You
difference.
disagree with, that's what trials are for.
Your Honor, the reason we may have a difference there is,
I know you
I
disagree
acknowledge,
with- I know you disagree.
and we say that trials are for, but trials must go through the process that we're going here. There was a significant, after almost 3 years of discovery and proceedings, this court asked at length the counsel for the plaintiffs, how would you get there? And sticking to the original complaint, which was paragraph 22, joint appendix page 53, it's purely a matter of subjectivity and gender stereotyping as the sole reason for any discrimination. It was not the rest of what you and I are discussing now. And that's what the court ruled upon. And in striking the class allegations, you and I believe, in another case, or in the case involving some amendment somewhere, would have a good discussion about whether ranges are the foundation for some discrimination. There's a potential there, yes, sir. But notably, it does not exist in this case because, and I do repeat, there is not an allegation, even in the amended complaint, that the creation of the ranges walled out females because of the kinds of things you and I have been discussing. That's not even in here. And the reason it's not in here is it's not automatic. Some people come along, male and female, from the outside, whom Family Dollar wants to hire, and they put them in accordingly. And yes, there can be discrimination, but that is what is mandated to be an individualized decision. And if it is not, if it became a class action subject again, it would overrule Walmart.
What were the ranges at issue in Walmart? What were the ranges in place at Walmart?
I don't know the numbers, Your Honor. I don't know. I don't know.
All right.
Happy to take more questions. This is a fine discussion.
Judge Gregory, do you have some more questions you'd like to ask? Judge Keenan?
Very well.
Thank you.
The issue here is our original pleading that it was a centralized system. Our amended pleading is a centralized system, and it's a one-stroke issue. If you have ranges, that's true, but you have dual ranges, one that is predominantly women, one that's predominantly men, and that is at the corporate level.
Had to do with the system being too individualized, that it left too much room for middle managers to exercise their discretion subjectively.
Sir, that's not in my complaint. It says centralized pay setting system in the original complaint. I don't know how you can interpret that word out of the complaint. It's just there.
Well, it's hard for me to read the original complaint and the amended complaint as being anything other than diametrically opposed documents.
Well, I've said why I disagree with that, but I also learned as a young lawyer you can plead things in the alternative. Many times lawyers, at an early pleading stage, they can't really pinpoint these things down, and so they have to go both directions. I don't think we did. We said from the beginning it's a centralized system, and we continue to say it's a centralized system, and you can't read that word out of our complaint. But even if you could, we are supposed to go with the facts. We're not supposed to impose all these concepts on top of the facts.
Well, of course that's true, but the difficulty here is that this isn't the first time we've seen this case. It's you're saying, well, we don't know, how could we be expected to know? But your opposing counsel said there had been 3 years of discovery.
That's not true.
Well, there have been suits all across the country. The Collins litigation in the District of Alabama involved extensive discovery of this very company.
Your Honor,
The litigation here has involved in the discovery. The district court made a finding that there has been, I don't know how we look behind that when it says, quote, plaintiffs have had adequate time to conduct discovery, and they have indeed conducted significant discovery in this and other similar cases against defendant in other jurisdictions. And then I think the court quoted something about saying a statement that you'd made saying that, or counsel representing plaintiffs says that the hardest part of discovery had been complete.
they had given us documents right before the argument. They had given us documents, electronic data. That's how we found out that women were making $2,500 less than men in the same job. They did give us data. They didn't give us anything else. They didn't give us their policies, and we did not depose a single witness. We begged to depose just the decision maker on this policy. We didn't get to do that. The judge said he had an expert report in front of him. He didn't. There's never been one.
Why did you say the hardest part of discovery had been completed?
Because they had given us that data. That's what they fight us on all the time first, is don't get the data so you don't have the statistic. Therefore, you can't tell what's causing the disparity.
Was the court entitled to take into account your representation that the hardest part of discovery had been complete, and was it entitled to make a finding that there'd been extensive discovery?
Certainly.
If this had been a lawsuit that just emerged from the fog, or that was just newly minted, that would be one thing. But it isn't newly minted. There's no reason not to charge you with the representations made earlier. And it bothers me that after the Walmart case, something's different required, we're gonna seek to amend our complaint and do something completely different from what we've done before. And we're gonna rule that a district court has abused its discretion
Judge,
in declining to allow that. What's that going to permit at the trial level?
if you're going to charge me with saying that the hardest part of discovery is over, you should give me the end of the sentence, which said, but we still need to take at least 5 depositions. We haven't taken one. That was the whole sentence. You're quoting just half the sentence. And we haven't got, you won't be able to find in the record any decision maker that will explain these things to you. You've got lawyer talk up here about something that no person at the company has ever described. And that's what Walmart says, no, that it's not a pleading standard. It's an evidence standard in Walmart. And I just beg to differ that you can ignore the word centralized pay setting in the original complaint and everything throughout the case. I also think if you go back and look at the timing of the discovery, you'll see discovery was closed, formally closed for the first 3 years. It opened in July 2010, closed again in August, opened briefly that fall, closed again in January, and that was it.
All right, but it still doesn't answer my point that the same corporation in the complaint and the amended complaint is discussed in diametrically different ways.
It's just not.
It is. The first complaint identifies the central flaw as subjectivity. The Supreme Court says no, subjectivity is a bar to class action treatment, and then we get a different complaint which describes the same company, but the name is the same, but the company operations are described in different fashions. These are different documents, and how can a district court be accused of abusing its discretion in taking that plus the amount of discovery that concededly has been conducted?
Because you'd take a half-truth if you were to take that as the complaint. The complaint doesn't say that. The complaint says there, and this particular amended complaint adds on to what we meant by centralized. Once we began to figure out what's causing this, the amended complaint explains you have a dual corporate imposed pay structure, a corporate imposed ranges, in which the one in which the women predominantly come up through is lower. It has a 10% cap. It's a corporate cap. There's no discretion. There's no subjectivity. It's 10%. It's a number.
Why wasn't that in the complaint?
It's in the amended complaint. It's in our brief against dismissing this case too. We described all this to the judge, saying this is what we've learned. Even if you ignore our amended complaint, this is what we've learned. And that's why 10% cap is not discretionary. It's just a flat number. And it's imposed by the corporate. And it works with the dual structure. Over in the women, they've got a 10% cap. Over in the men, they don't have a 10% cap. And the 10% is what I'm talking about, is 10% of their existing salary. When you take prior salary and you impose that as a criteria, you're perpetuating the past. You're freezing the status quo in exactly the way the Supreme Court said don't do it in the Griggs.
I don't know how that policy cuts, because it could cut in different ways in different jurisdictions. And in some instances, an in-house hire would be of a male, and in some instances it might be of a female, and in some instances an outside hire would be of a woman, and in some instances an outside hire would be of a man. But the point is, there's still room for discretionary implementation, as you yourself earlier underscored.
That's not true, Judge, in a disparate impact case. The impact looks at the criteria. It doesn't look at the discretion in imposing the criteria. It looks at the criteria on its face, and does it strike harder against women than it does men? If the answer is yes, you've decided the case in one stroke for the women. If you say no, you've decided the case in one stroke for the company. Now, if you past that point, that there is impact, disparate impact on the women, then you go to the next question. Is it justified by business necessity? That's a one-stroke decision. It's either necessary for everybody or it's necessary for no one.
Okay, but you have statistical disparity. Doesn't mean that every manager or regional district manager promotes in-house, or it doesn't mean that it doesn't or fails to accord equal pay or what have you. The statistical disparity doesn't, the Supreme Court in Walmart makes the case that statistical disparity doesn't get to individual determinations.
The Supreme Court said in a pattern of practice case, which is a disparate treatment case, but even there you don't get to the question of individual facts until stage 2. The Supreme Court said in Teamsters and said again in Walmart that for Title VII cases, at stage 1 you look at the broad pattern. You do not look, you're prohibited from looking at individual facts. And at that stage, once you decide in one stroke, is there a pattern?
We've been over this. I think you have, speaking for myself only, I think there's a difference here between what was originally submitted and what was submitted after Walmart, but we can agree to disagree on that point.
Yes,
I want to thank you for
Yes.
your argument.
Thank you.
We'll come down and greet counsel and then move into our final case.